Welcome back, viewers, to the PI Show. It's that time of the show. We've got Viv Mailbag, but seeing Viv's away on maternity leave, we've got Beth Alston. Welcome aboard, Beth.
Thanks, Tony, and thanks, Harry.
Another up-and-coming lawyer.
That's right. So I'll be taking care of Viv's mailbag while she's away, and we've got some great questions today. The first question is from Daniel in Elwood. Hi guys, after the last few months I've noticed that whenever roads or footpaths are being repaired, there don't seem to be many signs to warn people of the dangers. The other day I almost fell into a hole in the footpath because there weren't any signs to show that the hole had been dug. If I had fallen in, could I have sued the company or the council? Well, Tony, this seems very similar to the case of Hayley in Maryborough that you were talking about before.
We've got to get to that, I think. But look, this is one where, because there's been positive action taken by someone, they've dug a hole. So someone's actually done something. You'd think that if it's in the control of the council, they've got a duty to take care, reasonable care. The issue about signage is important too, I would have thought, but then you've got to get to the next step, which is the obviousness of risk. Now, if the risk is obvious, you shouldn't have just walked into the hole. You've got to watch where you're going. But on the other hand, if you're inadvertent in the sense that maybe you've got the sun in your eyes or there's something blocking your view in front of you, you'd think that your chances of winning against the council are pretty good. Or the person that's actually dug the hole, which could be a contractor.
There's two possible defendants, which is the council who have control of the footpaths, and also they usually private contractors come in and dig holes and repair footpaths.
Well, the signage and also barricades are the things that are probably relevant in those circumstances. So, I think...
But every case depends on the facts, but prima facie, I agree with Tony that it sounds a reasonable case. If there's a hole and there's no signage or barriers to stop people falling, you'd think that primarily the contractor would be liable, plus the council.
And if you're walking along and it's something that you can see, that might be an issue.
But you might be able to see it during the day, and then at night time, you can't see
if
it
it's
at all.
That's a good point there, Beth, because normally,
if it was dark, lighting, if it was dark, circumstances, people running, jogging, dare I say, walking a dog, all sorts of things can happen, and so we think the claims there's a potential claim. He almost fell. He didn't fall. No. Thank goodness. So
I think the advice to Daniel is just watch where you're going, firstly, and secondly, make sure if you fall, it's not during the day, because if you do, I don't think you got much of a chance.
Oh, no, I don't agree. I don't agree. No, if there's a positive hole and someone's actually repairing a footpath, I think the prospects are reasonable.
It depends on the activity too. I mean, if you're just walking along, you'd think your prospects are less, but if you're sort of jogging at full pelt...
I think it's a reasonable claim.
Okay. Well, thanks for that question, Daniel. The next question is from Chelsea in Carrum Downs. To the PI Show, I recently broke my arm and a few ribs when a large billboard fell on me in a shopping centre. The sign was about the size of billboards that are usually placed outside homes going for auction. I think that the shop was negligent in placing such a large billboard in the shopping centre and for not securing it properly. Following the accident, I spent 2 weeks in hospital. As a result, I got some pretty hefty medical bills, and because I didn't have any sick leave, I had to take unpaid leave. Can I get any of this back from the shopping centre? Well, what do you think about this, Harry?
Seems to me there's a prima facie claim. What would normally happen is you'd write a letter of demand to the shop and put them on notice. You try and quantify what you've lost so that you'd put into, in particulars, the medical expenses that you incurred and also time off. So you need some evidence from your employer that you've had time off.
So she can actually get some of her pay back that she missed while she was
You should be able to get
working.
all her pay back, and you should be able to get all her out-of-pocket expenses that she's incurred. And if she's suffered long-term injury, then you can sue for pain and suffering. If
you've got to satisfy 5%,
more than broken arms and broken ribs, so they might heal. The best result for her is if they do heal, but if they heal, she's got no entitlement to sue for the pain and suffering she's
She might
gone
have
through.
complications, Harry. You don't know. It's hard to
Yeah,
say.
but if those injuries do heal, then she can't sue for pain and suffering, unfortunately, because you need a threshold of more than 5% permanent injuries to sue. So it's a threshold. The Wrongs Act was changed in 2003 to stop people suing for minor injuries or
So
getting
that's
pain
the
and
5%
suffering.
you were talking about earlier in this show.
Yeah,
is
get-
that
getting-
right?
I
Yeah.
think Chelsea's well versed in the law because she's hit the nail on the head when she says the test on negligence is failing to secure it properly. So
Yeah.
I think that's a good starting point.
Yeah, dare I say, Tony, raise ipsa loquitur.
Yeah, possibly.
The facts speak.
yeah,
The facts speak
yeah,
for
they do, but
themselves. So
it's-
a billboard should not fall on someone if it is properly
That's right.
secured.
That's correct.
So
So
the
it's
facts
not only
speak for
doing
themselves.
something,
Yeah.
it's failing to do something, failing to properly secure it.
Failing properly to secure it. So
I think get some legal advice. That's the advice.
Well, we
to
give.
Chelsea.
Yeah, she's seeking our advice, and our advice is she's got a viable claim.
All right, thanks for that,
A
Chelsea.
viable claim.
All right, our last question is from Sophie in Melton. Hi, I recently took my 5-year-old daughter to see the doctor because she had a really bad cough. The GP told me that she simply had a cold and that it would go away. He didn't check to see whether she had a fever, and we didn't check at home. 3 days later, her cough got really worse and she got a high fever, almost hitting the 40-degree mark. We rushed her to the hospital and it turns out she had pneumonia. Because it had been untreated for quite a while, she would need to be on antibiotics for much longer than if it had been diagnosed even 3 days earlier. Can the doctor be sued for this misdiagnosis and be liable to pay the costs for the medication? And can I get any compensation for having to take time off work to look after her?
Yeah, look, it's an interesting case, but my first advice would get a new doctor. That's what I'd be telling.
Well, it's a misdiagnosis.
But,
yeah.
So it's a medical negligence, perhaps?
Yeah, but I don't know if there's much of a loss here. I mean, you might send a letter like Harry says. Send a letter off to the doctor and he might just want to pay for your time off work and extra bills that you've incurred, but it doesn't sound like there's going to be permanent damage. You know what I mean? Pneumonia, generally, people recover. Unless there's some sort of complications, Harry, I would have thought that there's not a lot in this.
Well, if she's 5 years old, pneumonia might have a more devastating effect to her. Time will tell, I guess.
Yeah, it's a matter of time. And plus, being a 5-year-old, you've got until the age of 21, I think, to sue. So,
Okay.
yeah.
Yeah, you've got a long time period, but initially we don't think there's a claim on those facts. Unfortunately, we don't like saying no, but unfortunately we don't think there's a
Get a new
viable
doctor,
claim.
I think.
Yeah.
It's that time of show.
But that's all we've got time for tonight. We'll be back next week with some more discussions about personal injuries. And thanks very much for watching. We'll see you next week.
And keep
Thanks,
writing
Beth.
in with your letters because we love to read them and we'll answer them in the shows to come.
Welcome aboard.
Thank
Beth.
you.
Thank you, viewers.